Okay, let's just jump right into this. Welcome to today's deep dive. We are looking at a stack of documents from a DOJ investigative report.
Yeah, and it's a really fascinating report.
It really is. It focuses on a high-stakes personal injury case called Kathy Morrow v. Wal-Mart, Inc. And frankly, this reads less like a legal brief and more like a noir detective novel.
Right? Because on the surface, you just have a standard slip-and-fall case. But the investigation claims we aren't looking at a normal lawsuit. We might actually be looking at a closed-loop litigation scheme.
A closed-loop scheme.
Exactly.
It challenges the bedrock of our legal system.
Yeah.
You know, we assume litigation is adversarial. Two sides fighting tooth and nail for their clients. But this report suggests that in certain pockets of San Diego, the adversarial model might have been replaced by a business model.
Which they call spatial proximity.
Exactly, spatial proximity. I want to get to that because the details are actually kind of wild. But first, let's look at the facts of the case. The incident itself is pretty grim. In February 2020, Kathy Morrow trips in a pothole at a San Diego Wal-Mart. And this wasn't just a minor stumble. She ended up needing spinal fusion surgery.
Right. And the trial itself looked completely legitimate on paper. The plaintiff argued the pothole was a long-term hazard that Wal-Mart ignored since 2018.
And the defense? The
defense was led by Andrew Kohn of Pettit Kohn. They argued she was distracted by her phone and the pothole was trivial. You know, standard legal posturing.
Standard posturing, yeah. And the jury bought the plaintiff's story. In March 2024, they came back with a verdict of $2.45 million.
But then you have to look at the liability breakdown.
Right. So the jury split the fault, 65% to Wal-Mart and 35% to a third party called CBRE. They settled separately. So Wal-Mart is on the hook for roughly $1.6 million.
And that is where the anomaly kicks in. Usually a corporate giant like Wal-Mart is extremely aggressive. They appeal verdicts, they drag things out to preserve capital. But here, silence. They didn't appeal. They just cut the check.
Which begs the question, why? And this is where the DOJ report gets into the financial mechanics of what they call a managed loss. Because it's not just about the plaintiff getting a payday.
No, it's not. Think about the math here. It's about the medical liens. In these injury cases, there is an entire ecosystem of doctors and service providers holding liens on that settlement money.
So if the verdict is controlled.
Yes, controlled.
Like high enough to pay off the doctors and the lawyers' fees, but low enough that Wal-Mart doesn't panic and file an appeal, everyone in the loop gets their cut.
Exactly. It turns the lawsuit into an invoice. The defense counsel gets paid for defending, the plaintiff counsel gets their contingency fee, and the medical lien holders get cleared.
And Wal-Mart avoids a messy PR disaster from broader negligence findings.
Precisely. It's a closed-loop transaction.
But for that closed loop to work, the lawyers have to trust each other. They can't actually be enemies. And that brings us to the big reveal in the investigation, the spatial proximity.
Let's talk about the addresses.
I pulled the address verification for the lawyers involved. The defense counsel, Andrew Kohn, is headquartered at 1162 El Camino Real Suite 300 in San Diego.
That's totally normal.
Right. Professional. But then I looked up the plaintiff's attorney, Jonathan Kwan.
And where is he located?
He is at 11622 El Camino Real Suite 100.
The exact same building.
It's not just the same building. I looked at the floor plan details in the report. Suite 100 is a shared executive suite facility. We're talking shared reception, shared mail handling, shared conference rooms.
Wow. That changes the dynamic entirely.
Yeah.
The investigators theorized that when opposing counsel share this level of physical infrastructure, it creates an environment for managed litigation.
Right, because they're literally bumping into each other at the coffee machine.
Exactly. It's hard to go for the throat in the courtroom when you have to awkwardly share an elevator ride immediately afterward.
Hey, Andrew, pass the sugar. Also, I'm suing your client for $2 million today.
It paints quite a picture. And the report bolsters this theory by contrasting the Morrow case with another case involving the same defense firm, David Ruvalo v. Wal-Mart.
Oh, this comparison was damning.
Night and day. In Ruvalo, the defense firm didn't play nice. They went scorched earth. They used a tactic the report calls institutional attrition.
Denying the event even occurred, right?
Right. Even though internal records showed it did. They allegedly suppressed video evidence. They fought every single inch.
And the result was a take-nothing verdict. The plaintiff got zero.
Zero. So this proves the defense firm knows how to kill a case when they want to.
Which makes their behavior in Morrow look purely voluntary. They accepted the $1.6 million hit without an appeal.
That is the implication. Morrow wasn't a failure of defense. It was a choice to feed the ecosystem rather than starve it.
The report throws around the term institutional fragility regarding the courts. What does that actually mean for the listener?
It basically means the courts and the state bar are asleep at the wheel. They're relying on lawyers to police themselves. The system assumes that because two lawyers are on opposite sides, they're keeping each other honest.
But in a closed loop where everyone profits from the settlement, no one is blowing the whistle.
Nobody. It makes you rethink what you're seeing when you walk into a courtroom.
You think you're watching a fight for justice, but you might just be watching a business meeting between neighbors.
Which leaves us with a provocative question for you to mull over. When opposing lawyers share an address and a coffee break, are they fighting for their clients, or are they simply negotiating the transaction costs of the legal system amongst themselves?
Definitely something to chew on the next time you see a space for lease sign in a law building. Thanks for joining us for this deep dive.